You coming out to watch us today? What we do on these type of oral argument sessions is after each case is done, we ask the lawyers to tell the students a little bit about themselves, and we encourage the students to ask questions about to the lawyers or to the judges about things on your mind pertaining to what we do or what the lawyers do. Or we're not going to tell you about how the case is going to be resolved, but we certainly encourage questions. And if you're around at the end of the whole session, we'll be here for pictures if you want to take pictures. Don't feel obligated to do that, but we are certainly happy to have you here today. We have 3 cases this morning. Before we get going with that, let me introduce who's on the panel with me. To my right, your left, is Judge Rand Wallace. Judge Wallace is a former circuit judge down in Orange County. He's been on the court for about 9 years now. It's got family ties here. Wallace Medical Center, right by used to be called Monroe Regional. I don't know what it's called now. I keep changing it. Advent, but that was his grandfather who built that. Well, it was. There you go. So Judge Wallace has been around here, and to my left, your right, is Judge John Harris. Judge Harris was a former circuit judge in the 18th Circuit, which is Brevard County, and he's been on the court about 5 or 6 years, somewhere around there. Okay, so we're happy to be here. A couple things. Each side will have 20 minutes argument. Appellant, we'll reserve 5 minutes for you. You'll see the light come on, the yellow light come on once you get into your rebuttal time. If you want some different amount of time, let me know. You don't have to stop once you're in rebuttal time, but you don't get more than 20 minutes in the aggregate. Anybody has any cell phones on or any other electronic devices, please put those in the off position. Or the mute position, so it doesn't interfere with the arguments of the attorneys. And I guess we are being recorded. Our first traveling video recording process. We'll see how this plays out. So we can watch it. You can watch us on YouTube if you're got nothing else that you could possibly think of doing besides watching us. You can watch us on YouTube later. So, all right, first case on the docket is case 22-2344. U.S. Bank Trust National Association as trustee of the Chalet Series 4 Trust versus Susan Roxanne Hart, Robert Hart, etc. Whenever you're ready, counsel.
Good morning. Eric Levine here this morning.
Okay.
The order of involuntary dismissal entered in this case should be reversed, and this matter remanded for entry of final judgment of foreclosure. There's no dispute in this case at all that U.S. Bank Trust proved all elements of a prima facie case: execution of the note and mortgage, default, acceleration, amounts due and owing, and standing to foreclose as holder of the blank endorsed note. The sole basis for dismissal, and the sole issue on appeal today, is compliance with the face-to-face meeting requirement found in 24 CFR 203.604. Judge Lambert, you wrote, discussing the face-to-face requirement, quote,
So you want to rely on something I wrote?
and
Good luck with that. Go ahead.
And concurred with, which addresses the mortgage servicing responsibilities of lending institutions with regard to mortgages insured by HUD, which of course is absolutely correct. It should not be surprising to anyone that HUD,
right?
You got it right.
Yeah.
That apply only to loans insured by HUD. We filed supplemental authority last week. I don't know if the court saw it, that the Iowa Court of Appeals, obviously it's a federal regulation, said the exact same thing last month. The trial court here erred that the HUD regulations apply not only to loans insured by HUD, which of course the court said in Palma, which Judge Wallace you wrote, and Diaz, but for loans for which HUD insured.
You want to rely on something he wrote too, then. There you go. All right, 2 for 2.
I'll keep it to myself who wrote the opinion. The court here said not only does it apply to loans that are insured by HUD, but also loans for which HUD insurance had been canceled years prior. This, of course, is contrary.
But this loan was insured from 2002 to 2012, if I understand.
I believe so, yes.
That's your position. It was canceled in 2012, and therefore the regs don't. Your requirement of complying with the regs ended when it was no longer an insured mortgage?
Based on the plain language of the regulations, section 321 that talks about termination of insurance.
And Mr. Levine, in your complaint, your client pled compliance with all conditions precedent
Generally.
to foreclosure, correct?
We pled generally as required by, I think, Rule 1.200 or 1.210.
Okay, so when you say generally, are you saying it was more boilerplate, where there was actually, it was not catered to the actual facts of the case? Or are you alleging that specifically your client complied with the conditions precedent?
As required or permitted by Rule 1.210, we pled satisfaction of all conditions precedents were satisfied generally, and then the burden of they did, and we filed the reply saying that no, we don't have to do that because HUD insurance was canceled. And then
and then I believe also there was an affirmative defense that was pled on behalf of the mortgagor, correct?
They do, although it's basically a waiver of the argument. Then in their affirmative defenses, they pled as an affirmative defense, you didn't comply. Then in our...
But regardless of that, there was still a burden of proof on your client when you appeared before the judge to prove your case that you had still complied with the conditions precedent. Is that correct?
No. Well, it depends. As the court said in Diaz, a plaintiff's obligation to prove compliance with condition, the applicability of the condition precedent. So when we put in our reply that we didn't have to comply with the face-to-face requirement because HUD insurance had been canceled, the burden was on the defendant to prove the HUD insurance was active. If they had proven,
okay, but when you say that, because the HUD insurance was canceled, are you assuming a burden of proof with regard to that because?
No, we're not assuming
so
the burden of
that's
proof.
An allegation without any proof that you're saying satisfies and puts the burden back on the mortgagor?
The reply put the mortgagor on notice that they had an obligation to prove the loan was actively insured.
But the general...
There's references to them both, I believe, yes.
Okay, and there's reference to the secretary.
Yes.
That's the secretary who's the head of the Department of Housing and Urban Development, correct?
Yes.
Federal government,
yes.
Right? Okay, all right. And so I believe the bigger issue in this case is the lack of proof that the HUD insurance had actually been canceled. That was what the judge focused on. Specifically, it's replete throughout the final order. Is that correct?
The final order, so we did prove at trial that the HUD insurance had been canceled. It's Exhibit 4, entered into evidence that showed the insurance was canceled, plus coupled with the testimony of our witness, Mr. Fogelman.
But his testimony is only germane if that document comes in evidence. In other words, he can't just sit and say, I've looked at a bunch of things in the file, and oh, by the way, Judge, the insurance was canceled in 2012. You agree with that?
I would agree with that, which is why Exhibit 4 was admitted into evidence.
And Exhibit 4 is not, you wouldn't say it's the most clear of documents to explain. I mean, it's not a letter that said, Dear Mr. and Mrs. Hart, congratulations, your insurance has now been canceled because you're now, you paid more than 20, and that would be clear, and the judge couldn't then just say, well, I see you got the letter, but I don't like the letter, so have a nice day. I mean, this is a vague document that your trial witness, then testified about. But if you just simply gave somebody in the audience the file and said, look at this letter, what do you think this means?
Well, that's why we have a witness.
Well, I know that, but I mean, that became the problem with the judge, though, in his final judgment.
Well, this is an interesting point, because at the actual trial, that is not at all what the trial judge did. At the actual trial, in the transcript, Judge Merritt was allowing this in, and he said to the defendant, if you want to move to strike it, if you come up with proof that this is not reliable, you can move to strike Exhibit 4. No motion to strike Exhibit 4 was made. He then
bench trial. It's a bench trial.
It's a bench trial. Yeah.
Okay. Pre-trial, the judge is going to give the jurors the instruction that you can rely upon all of the evidence, none of the evidence, or some of the evidence, correct?
In a jury trial, the jury...
Disregard, even if an exhibit is admitted into evidence, the jury could look at that exhibit and decide to either believe what the evidence that's contained in the exhibit.
That's what this court said in U.S. Bank versus DeVoe, that in a mortgage foreclosure case, the documentary...
What about unreliable evidence?
there's no finding or any basis in the record to find it unreliable.
Well, you are hinging the proof of your case upon specifically with regard to the canceling of the insurance, this one exhibit, Exhibit 4, correct?
This Exhibit 4?
Well, state it a little differently. If the judge had sustained the hearsay objection, there's nothing to show that it was an uninsured.
I believe that would be correct, other than
Why
perhaps through the
wouldn't it be
witness
correct?
testimony. I think that would be correct.
Well, I know, but he can't then testify and say, well, you sustained, you not allowed it.
This laid a proper foundation for the admissibility of Exhibit 4.
Well, then that kind of begs the point. I mean, in essence, in his judgment, his final order of dismissal, didn't he basically say, I shouldn't have admitted that documented evidence, I'm not going to rely on it, and it has no weight, so have a nice day, and therefore...
Well, problem with that is twofold. One, it's completely contrary to what he said at trial, and the order that he signed was completely written by the defense counsel, which I know that this court has.
You don't get to object to it. I mean, you guys had post-hearing discussions about it. So
on that point, the document was admitted into evidence at trial. The order never strikes it from the evidence, never says it's out. It muses, maybe this is not the best reliable document because it's kind of vague, maybe. But in any event, in a non-jury trial, in a civil case, well, actually jury trial too, in a civil case when the standard is a preponderance of the evidence, and we say we have testamentary evidence from the plaintiff supported by documentary evidence from the plaintiff, and we compare that, even if it's not a strong scale with the defendant's nothing, zero evidence, that carries the day. And that's what the DeVoe case was talking about when this court said you don't arbitrarily reject unrebutted evidence. And I understand the evidence could have been stronger.
Exhibit 4 doesn't reference anywhere on it the Department of Housing and Urban Development or HUD.
I believe it says, I think it says HUD on it.
Well, I have Exhibit 4 right in front of me, sir, and I beg to differ with you on that.
I didn't have it in front of me, but it does say insurance canceled.
It doesn't say insurance canceled either.
I think at the very bottom. I was just looking at it before I
I have Exhibit 4 in front of me, and it does not say insurance canceled.
it's a vague document. I mean, there is no way that if you just gave that document to somebody and said, what do you think this means?
Well, the last line, Exhibit 4, says contract of insurance termination date, 11/30/12. Contract of
It
insurance.
doesn't say insurance canceled.
Well, it says contract of insurance terminated.
Okay. Does it reference HUD anywhere in that document?
No, I'm sorry. It does not appear to reference HUD specifically. It says contract of insurance termination date.
Does it reference the name of either U.S. Bank or Ms. Hart?
It does not reference the borrower's name. It does reference the servicer, Bank of America, at the time, I believe.
Does it reference the...
For insurance benefits at the top.
So is it your position is the judge can't say, he takes it under advisement, he then starts looking at the evidence and says, this is just apply if it's an insured mortgage. And I kind of agree with what Judge Wallace is saying, that if it's an uninsured mortgage, then you're right.
Mm-hmm.
Maybe I'll save some time over here. But anyway, but so the issue really is, did you prove it was uninsured? Because it was insured. From the get-go, it's insured. You have to prove, because it was canceled in 2012. The judge, over objection, admitted the document. Now when he writes his final judgment or he signs this, it's completely unreliable, or whatever term you want to use, whatever he said. He made it clear in his was canceled. You agree with that?
I think he did. He obviously didn't think it was sufficient to prove the cancellation of insurance, but then went on to say, even if it was, I'm still going to rule. He then said in the alternative, insurance.
Well, let's say he's wrong on that part.
Okay.
All right. So and the other part is, and you agreed early on, if it's insured, you have to comply with the 204, and you did. Did the trial judge err when, after the trial, he basically signed a final order that's saying, Exhibit 4 shouldn't have basically come into evidence, I was wrong, and with that out, they haven't proved it's uninsured, therefore, they haven't met their conditions proceeding because they didn't have the face-to-face.
Okay.
That's the
I think that's
case.
what. Yeah, I agree.
Okay,
I think then to Diaz, it was never our burden to prove the cancellation. It was always the defendant's burden to prove the HUD insurance was still active, and they were on notice of that burden in our prove it had been canceled.
Does it matter at this point? Because basically he's sitting back and saying, okay, that's your best shot. I mean, it was a pretty tough roll of the dice. He says, if that's your best evidence, I don't think you've proved it's been canceled, so I don't need to put on a defense.
Well, I think he would need, because I think the prejudice part of the appeal also would get past that. Even if we said that the burden was on the plaintiff to prove that it was canceled, to firmly prove cancellation, and the plaintiff failed to do that, which I know that we obviously disagree with, but let's say that's the correct. Then we get into the prejudice analysis. And if loss mitigation has been attempted and failed, the failure to comply with the face-to-face reg is not prejudicial. And here we have testimony that the borrowers, the
Does that occur after the suit is filed?
I'm not sure.
Does that matter then if it does?
I don't think it matters because I think it's the exact same analysis either way. I believe the testimony was that they were offered a permanent modification and they never returned the document. That's what this testimony.
Your rebuttal, but you go ahead.
Sorry, I'll finish up. So I think then even if the court finds that the face-to-face non-compliant prejudice, they can't prove prejudice because they didn't put on any evidence whatsoever, and the evidence that was in showed that they were given a permanent mod and they refused to accept it. So I'd like to reserve the rest for rebuttal.
Counsel?
Please, the court, your honors. I represent only appellate Robert Harkey on this particular appeal.
What's your name?
Jack Hogewind, Hoogewind. I was the trial counsel as well. Your honors, as far as the Palma and Diaz cases, they're both correct. That way I can be good for both judges. But Diaz, the facts in Diaz is that there wasn't anything in the mortgage that was introduced by the lender in that case that even referenced HUD regulations. What they were trying to do in Diaz is say that, well, because it's a Fannie Mae mortgage, we know that it must be FHA backed. So that made sense. In other words, there was no threshold evidence either by the plaintiff in their case or by the defense that the HUD rules even applied. Then Palma's a completely different case because in Palma, written by Judge Wallace, there's an express inclusion, if you will, of all the HUD regs. And then in that case, the court said that because of that, the burden was on the plaintiff to show compliance with the conditions precedent. So the two cases are completely reconciled. It makes sense. And what we have in our case is a Palma situation, not a Diaz situation. The mortgage incorporated it, therefore they had the burden to show they complied.
Mr. Hoogland,
yes.
Could you speak to the argument or the position taken by Mr. Levine as far as the lack of specificity with regard to your denial of conditions precedent?
Judge, I think first of all, it wasn't raised. There's procedural and then substantive. Procedurally, it was not raised in the trial court. If you look at the oral arguments at the end of the trial, there was no suggestion by the counsel for the bank that somehow they were misled by the pleadings, that they didn't know that they had to show it as a condition precedent, or that it wasn't pled specifically where you put the exact same thing in the answer that you do in the affirmative defense. So they did not raise that orally. In their initial motion for rehearing, they did not raise that as an issue. The motion for rehearing that they first filed never says, well, we were misled. We didn't really know it was a condition precedent. Even though we took the bull by the horns, we tried to show cancellation. Somehow we were misled. They didn't say that in their motion for rehearing either. It never even...
So maybe for benefit of the unique gallery that we have here before us today, what you're getting at is we are an error-correcting court, but that requires the trial court to be advised of every potential error to give the trial court the opportunity to correct that error.
That's exactly what I'm saying, Your Honor. And there was nothing said to Judge Merritt, who's hearing this case, oh, well, we didn't know we were supposed to perform a condition precedent. We didn't know we had to show that the mortgage was canceled. That would have been ludicrous because we spent most of the trial with the bank taking the bull by the horns trying to show cancellation. Also, when they filed their reply, they referred to the HUD business as a condition precedent. They used that verbiage, albeit saying that it was the defense's burden.
With regard to the affirmative defense, did your client specifically plead failure to comply with the HUD regulations?
Yes, specifically that and referencing the section itself, which I think is 203.604. So, and the final thing is whether it's even preserved in this court. You get to the question of if you raise the issue, in this case, the one Your Honor is alluding to, in 2 or 3 sentences as part of a sub-issue, is it preserved on appeal? I dealt with it in my reply, in my answer brief, because I'm never really sure just how much you have to raise an issue before it's even raised.
Neither are we.
No, I mean, I can't find any guidance, and that may be my ignorance, but I know that I clearly I don't think a footnote issue is preserved because that's clear.
Depends on which member of the court's on the panel.
Okay, but as far as can you raise an issue in a sub-issue with two sentences not highlighted, and then do I have to respond to it? In abundance of caution, I could maybe see it coming, so I went ahead and briefed it, and responding kind of the same way I'm to Judge Wallace, but also saying the issue was litigated by implied consent anyway. If the bank truly thought that this was an affirmative defense and not a condition precedent, there's no earthly reason for them to spend all the time trying to prove cancellation. In other words, if you really think something has not been properly raised, you don't deal with it at all. You just have the witness testify that they had performed generally all conditions precedent. But
let me ask
I apologize, sir.
Let's assume that we think that the regs apply only if it's an insured mortgage, which it was.
Yes.
For 10 years, 2002
Right.
when it was first executed till at least 2012, and they said it was, that's their position, was terminated in 2012 before suit was filed,
Yes.
et cetera, before default, et cetera. All right, so if we take that out of the equation, so now it has to be insured, and the trial judge admitted Exhibit 4 into evidence, which according to the testimony provided by the bank's sole witness at trial, tied in Exhibit 4 saying this is what Exhibit 4 means. It is now in evidence. There's no evidence presented in the defendant's case in chief. So can the judge go back and say, all right, I'm going to enter a final judgment. I'm going to now basically say I was wrong in admitting that evidence and it carries no weight even though it's been admitted?
Without a doubt, judges have inherent jurisdiction to always change interlocutory rulings. I mean, that's the black letter law. I know nothing that prevents a judge from changing his mind and saying, and Judge Merritt did say when I objected at the trial that he had some reservations about letting it in. Mm-hmm. So it wasn't like it was a big surprise. And both parties dealt with it on their proposed judgments. I don't think there's any question that, particularly in a bench trial, a judge has inherent jurisdiction to change his mind. And if indeed there was any prejudice to the other side, for example, say that the plaintiff in this case said, "Judge, that ain't fair. We would have put on other evidence." Then, and had they raised that, for example, on their motion for rehearing, Judge, you kind of misled us here. You let that in, and now you're taking it away.
And that would be a fair argument to say we believe we proved
right.
that it was not an insured mortgage as of 2012, and therefore the regs don't apply. Right. And once we secured that ruling during the trial, we went forward, and now we get this piece of paper from you, or pieces of paper from you that says, oh, by the way, I'm throwing Exhibit 4 out the door. Now that applies, it carries no weight, therefore it's an uninsured mortgage, and
exactly.
Or it's still an insured mortgage, and therefore you didn't comply with the regs. That would seem to be
it'd be a great ground for a motion for a hearing, but they didn't do it. They filed a motion for a hearing. It said nothing like that. And the reason is they fully litigated as best as they could. But had they been prejudiced, first of all, they would have said it during the oral arguments when I moved for involuntary dismissal. They would have said, hold on here, we haven't had a fair chance, or I'm sorry.
Well, when you move for an involuntary dismissal,
it was coming in.
Yeah, it was already in evidence.
Yeah, that's the time that they could have, would have, should have, would be in their motion for rehearing. Yeah, Judge, come on, and I don't know what I would have said had they made that, because it was kind of a turnaround on the ruling, and had they done that, I think they would have, and that was the issue before the court, is, hey, the judge pulled the rug out from under us and wouldn't give us another look at it. I think they'd have a pretty good
because
case.
if we are of the position as a court that it's only when if the mortgage is insured that they have to comply with the regs, and the judge accepted Exhibit 4 and didn't do anything, then you would lose under my hypothetical.
I think they get the new trial if they move for it, but they never did. That's the problem. They never moved for a new trial on that ground that, Judge, we would like to have put more evidence in. And, the final thing is, and I think on the exhibit, I don't think I have to belabor it, but it's an abuse of discretion, test. Reasonable people can differ. I mean, I honestly feel if I was here and the judge had let it in, that this court might say the judge may have abused his discretion in letting it in or keeping it in this case. But the test here is, did the judge abuse his discretion at looking at that piece of paper and say, I just can't let this in? And then you have yet another question is, even if it came in for some limited purpose, the judge also ruled in the alternative in the final judgment that even if that was considered, there's no substantial competent evidence, which is always a test, and that can be raised for the first time in appeal, although I raised it in the trial court.
But that is substantial. I mean, let's change the verbiage of Exhibit 4. Let's say Exhibit 4 said, dear Mr. and Mrs. Hart, I'm the Secretary of HUD. Insurance on your mortgage is canceled, so you now have to pay the PMI anymore. Good luck. Have a nice day. Your side would be very happy about that because they're paying less money. But the letter would be clear, and the judge can't say, well, I see the 2-paragraph letter told you your insurance is canceled, but I'm going to disregard.
I agree 100%. I mean, I agree with
it's the quality of this Exhibit 4 is the issue, as opposed to the fact that the Exhibit 4 could have. Exhibit 4 written better could have ended your case.
Exactly.
All right.
I don't think there's any doubt about that. And I agree with counsel that if there's evidence that's clear, you've got to accept it. But on its face, the document was problematic. And there still has to be substantial competent evidence. There's been cases where evidence comes in, the judge just says it's not substantial competent. I don't know how, respectfully, that Judge Merritt could be overruled, first of all, in saying, I just can't let this in. And second of all, if it's going to come in, what does it mean?
But he let it in, and then he unlet it in
Changed his mind.
basically when he wrote his final judgment. I mean, so
Exactly.
in their defense, it was in evidence, so they thought, okay, we've gotten past that hurdle of whether it's no longer an insured mortgage.
And I agree with that, but the judge has inherent jurisdiction to change his ruling. Their response, if they're prejudiced, if they've got something else, is they move for a rehearing on that ground.
That's kind of your best argument then, basically saying if you think we got sandbagged by the judge's final judgment, you should have brought it to the judge's attention saying you can't do that, and by failing to bring that to the judge's attention to allow him to correct his error and go back to where he was correct in the first place from their side, then that's problematic on the appeal.
Exactly. That's exactly what I'm
What's
saying.
your client's prejudice?
The judge, on the case law, Your Honor, every case that's cited by the plaintiff, when they say there has to be a showing of prejudice, is where there was a showing of substantial compliance. If you read every single case, it's always the same thing, that every case talks about if there's substantial compliance, then the burden shifts to, in this case, Mr. Harkey, to show prejudice. What we have in this case is no compliance. Every single case they have, Your Honor, Koonsman, for example, the one they cited, the initial time around, there was no compliance. The case was dismissed. Then they reset the clock, tried to do mitigation, and then the second time around, there was pre-suit compliance on Koonsman. The second time around, they sent a letter, they tried to get a hold of the person.
Well, let me ask, are you saying this mortgage modification took place after suit?
Oh, definitely. There's no doubt about it.
I mean, because what he's kind of saying is like, okay, the regs say we have to have a face-to-face meeting. If we don't have a face-to-face meeting, you've not complied with the conditions proceeding. But, the whole purpose of the face-to-face meeting is to talk it out and see if we can work it out. Right. Well, we did work it out. We gave you a mortgage modification, and you were to make 10, 11 payments, and you did. You just forgot to sign the document, your side or the ex-wife, and that's why it didn't become a permanent modification. So you're not prejudiced because the face-to-face meeting, we've accomplished that because we worked it out with you.
The problem is it was all done. It was done 2 years post-filing.
So you're saying once it's post-filing,
doesn't do any good.
It doesn't matter because it's not a condition proceeding.
Exactly. And also the whole idea of the face-to-face thing is to try to keep these mortgages, keep people in their homes. That's it. The whole essence of the HUD program.
Well, that was the mortgage modification, was to keep your people, or keep your client at least in the home. I know your wife, and his wife divorced.
But the idea of the face-to-face is to avoid problems before the case is filed. I believe in Palma, the text of Palma, and I've cited a couple cases that indicate that the compliance or the substantial compliance has to precede filing. If it does, then you have substantial compliance. Then Harkey, my client, has to show prejudice. If there's no compliance, he doesn't have to show prejudice. For example,
well, let's walk this. So let's say the mortgage modification took place before suit was filed here. They didn't have the face-to-face. They said, don't worry about the face-to-face. Here, we'll make you a deal. Pay these next 10 payments, and we'll modify the loan permanently.
Substantial compliance, and Harkey would have had to show prejudice. I agree 100% that they could have
in
already.
that scenario, he probably couldn't have shown prejudice.
Exactly.
Because he's been given the chance to rectify the default.
Not necessarily with a face-to-face, but
Right.
the purpose of the business was accomplished.
Right.
And then the burden shifts to me or to Harkey to show prejudice. Why didn't that solve your problem? The problem
Right,
that
and it
occurred-
wouldn't have solved your problem because you said, well, okay, you didn't meet face to face, but so what? You got a deal
You
and
got-
you worked out a deal and you
yeah.
paid all the payments and they did a great job helping you out.
Exactly. You got your loan
But
money.
you lose.
Yeah.
All right.
So I lose that way. But what happened here is the modification activity was 2 years post-filing. You can tell that by the testimony of Mr. Fogelman, the representative. The payments came in, and he puts a date on it that's like 2 years after filing. Everything's after filing. In fact, the servicer in this case didn't even get the case until a year and a half after filing. So there's no question in this case that the mod payments came in after filing. It's a post-filing modification agreement. Palma is, I believe a direct quote from Palma indicates that it has to take place prior to filing. There's other cases that say the same, and that would be the general rule. If you have a condition precedent that has to be established, it's ordinarily something that has to be complied with prior to filing. However, if
Well, they
there's
call it precedent, right?
yeah, that's what exactly. Now, what Your Honor was referring to, the prejudice that counsel's talking about, every case he cites, you're going to see substantial compliance. Koonsman is where, like I said, it was a reset, there was a dismissal, and then prior to the refile, there was compliance. There was letters that went back and forth. There's a bunch of cases that the bank cites, they're paragraph 22 cases, and it's typically the thing where a letter goes out and they may tell them a lot of things, but they don't tell them they have a right to file a legal action or something like that. In other words, one of the requirements that we see, and what the courts have said, and I believe this court in the Second District particularly say, look, I mean, it's not that big a deal. I mean, they tried, and now if you can show us prejudice, why 29 days as opposed to 30 makes a difference, or they gave the wrong date where they had to
We had a
cover.
lot of discussion on the court about that, actually.
But
It's Gorell, I think. Is it?
I think is the case. But the idea there is now, show us how you got hurt by that, and if you can, maybe you still win. Okay? But that's every one of those cases. I couldn't find a single case, Your Honor, where this prejudice thing applies where there wasn't substantial compliance. And that's in the paragraph 22 context as well as the HUD regulation context. The problem is, we have no compliance. We have no compliance, no showing of compliance. They hitched their whole defense on the idea that there was a cancellation. They didn't prove that, certainly by competent substantial evidence. In fact, we don't feel by any evidence, because the judge certainly couldn't be faulted for excluding this, exhibit. And the final thing I want to indicate is the lack of corroborating evidence here is absolutely stunning. When you look at the substantial competent evidence test, I mean, is there no other document in this world the bank could not have brought to bear to show a cancellation, like a letter saying your insurance is canceled, some back and forth? Is that all they have? And that's very problematic, because some of these cases, when they talk about this, they say, was there any corroboration? All you've got is this screenshot. I don't know how we can reverse, respectfully, how Judge Merritt can be reversed for that. I did put a tipsy coachman argument here. I'm not going to argue the second point, because the court's pretty much told me that you looked at me like you might not want to go there.
You tipsy coachman. I don't think that's going to. You got 2 minutes. I need to double check.
No, I'm not going to spend time on something when you say the tipsy coachman isn't going to fly. But thank you, Your Honors, very much for your attention. Unless you have any other questions. Thank you.
All right, counsel, thank you. All right, hang on. I pressed the wrong button here. Hang on. Hang on.
I thought I was going to get another 20 minutes.
Yeah. I guess we probably should have a marshal. Press the wrong button.
I think
All right, we'll give you 4. How about
All right,
that?
I think
it's
that's
a little
about
bit more than you had. So.
I got 2 points I want to make. I'll make them quickly. So about Exhibit 4. So Judge Lambert and Judge Wallace and Judge Hart, I think the discussion was, are we talking about whether Exhibit 4 was admitted and then thrown out of evidence, or is it in evidence and the judge just weighed it as being kind of weak? The answer is it was never thrown out of evidence. If you look at the judge's order dismissing the case, he did talk about how maybe it should not have been admitted. Maybe he talked about it. Maybe the foundation wasn't there. But I don't believe there's anything in there that says, you're out. You're kicking it out. There's no Exhibit 4. Exhibit 4 doesn't exist anymore.
Well, he says that it may not be considered by the court because he didn't think much about it, and if he would only have gotten better case law from counsel at the time of trial, he would have got the right answer.
And that's a weight issue. That's a weight. It's in evidence, but I don't know if I can really look at it. I don't know if it tells me anything probative. That's a weight issue. But when you have a civil case like this, where you're talking about a preponderance of the evidence, and you're saying, we have weak evidence, and I understand it's weak evidence.
What if he said, instead of saying it says little evidentiary value, what if he said it has no evidentiary value?
And I'm striking it from the evidence, then I think that...
Well, let's say he wasn't as accomplished in his speaking as you are, and said, he's an older guy. So the document has no evidentiary value.
Because he was talking about, are we on notice to try and reopen the evidence? Kind of what he's saying. He should have come back and complained, Judge Merritt, no, you're ambushing us by changing your mind. The problem is that if unless the court tells us,
that's kind of how I read it.
I'm kicking it out.
You guys had a documented evidence that you were relying on, and then he comes back and says, yeah, boy, I really blew that one, and so I won't say that I'm going to throw it out, but it has no value whatsoever, so I'm not going to consider it.
In that situation, though, Judge, I think we still come back to the same argument that this evidence compared to nothing presented by the defendant, the test, because he didn't say, we still have the testimony, but I still think under DeVoe, you still have to give that weight over the defendant's nothing. But I want to read something about prejudice, because I think we can also resolve this appeal on prejudice. Now, the appellee said, well, all those other cases deal with substantial compliance, and if there's no substantial compliance, and if compliance is only substantially, then you get to prejudice. And that's not at all what Koonsman said. And I'll read briefly. It says, even if Wells Fargo's effort at substantial compliance fell short, we would still affirm. So even if there wasn't substantial compliance, they would still affirm the judgment. Because after all, as Wells Fargo argued in its avoidance of the Koonsman's denial of performance conditions proceeding, the parties' failed loss mitigation efforts subsequent to the Koonsman's default preclude them from proving that they were prejudiced by Wells Fargo's failure to strictly comply with the face-to-face requirement. I think that is telling you that really you look at the practicalities.
But isn't the practicality that all of this should have taken place before your client filed the lawsuit?
The difference between should have, best practices...
Well, but I mean, that's the whole point. The whole point is to keep another case out of the courthouse to resolve the dispute. But it doesn't, it's almost like ready, fire, aim, It doesn't work if you're, we can work on this mitigation, but we're going to do it after we file suit. That kind of defeats the whole purpose of the law. Is that correct?
I will point out that the law does allow for an action to be abated to satisfy a condition proceeding. I know that's not specifically what happened here.
Did you abate the action?
I'm saying it didn't specifically happen here, but there is case law that talks about abating an action to satisfy a condition proceeding. So it's not as absolute as that. And in this case, if the judgment is not reversed and we have to refile, could we then say, look, during the pendency of the prior action, we gave you a loan mod and you turned it down, so now we can go back without doing it again? I mean, the action is just going to be refiled again. So it's not being kept out of the courthouse. So I think in this case, because all the evidence, weak as it is, showed that the HUD insurance was canceled in 2012, and there was no evidence of prejudice, and the evidence showed they were reviewed for a loan mod. From a practical standpoint and a legal standpoint, the judgment of foreclosure should have entered, and we asked for this dismissal to be remanded for entry of final judgment of foreclosure.
All right, thank you, counsel.
Thank you.
Thank you.
All right, now this time, all right, Mr. Levine, why don't you start with you since you're the appellant? Why don't you turn around and tell the audience who you are and your practice and
Sure. Good. A little bit. Hi. Eric Levine. I'm a partner with the law firm Atlas Solomon. It's based out of Stewart, Florida. Board certified in appellate practice. I've been a member of the Florida Bar since 2009. As you probably can tell, I represent banks a lot and mortgage servicing companies in foreclosure cases such as this one. I've been doing that for 10 years. Do I take questions?
What did you do? Where'd you go to law school, and where did you start your practice? What did you do?
Okay, I'm a 2008 graduate of Harvard Law School. I worked in New York City at a law firm for a couple of years. I moved to Florida in 2012. I was at a law firm called Ackerman LLP for 10 years until I joined my current firm almost a year ago, in June of 2022. While I was in New York, also represented, didn't do too much bank work, but represented different companies in various commercial litigation. And while I was at Ackerman for 10 years, I did a lot of this work representing servicing companies. And different banks.
You weren't the person who was actually the trial lawyer in front of the judge here.
I was not the trial lawyer in front of the judge here.
So you pretty much do that. You're not still like we see on TV with juries and stuff like that nowadays with your practice.
No. You'll find me in the DCAs a lot more often than you'll find me in the trial courts.
Mm-hmm.
So,
How long did it take you to prepare for this case today?
I drafted the briefing myself, so each one of those briefs that you read probably took somewhere from.
I'm not trying to get you tied in about your billing here.
I know. He's writing it down for the fee.
What did he say? He really only spent this amount of time?
I probably between 5 and 10 hours for each brief, and then probably 8 hours to prepare for oral argument. It's tough, as you can see. Sometimes I don't know what questions they're going to ask. I have to kind of anticipate and try and best guess. And sometimes I'll ask you a question, and you're like, I don't really remember exactly the answer to that, but this is my memory of it, and you hope to get it right as best you can. And if you're wrong, you have to immediately say, like, hey, I misremembered that. This is what it is. If you're wrong and you don't know up to it, they'll know. They'll know. Especially Judge Waltz, he knows.
Really?
Well, and I think the skill too, which both parties, with both attorneys really exhibited, was answering a question, stopping what you're trying to communicate, answering the question, and then getting back on, your theme or what you're trying to argue in the case. So.
Yeah, that's it. For those of you students, if you ever want to become a lawyer, whether you're in front of us as appellate judges, or we're all trial judges too. I was actually a trial judge here in this courthouse for 14 plus years, and the one thing you'll find that all judges like is when they ask a question, please actually try to answer it instead of telling me, the moon's over here or something like that. And they both did a nice job being responsive to they may not like the question, but that's the purpose of why we're here. We have things on our mind that we want to clear up, because once they're done talking, that's it. We go back and decide how we want to decide this case, and so that's why we try to get questions out.
Even if the lawyer thinks the question is a silly question.
It's happened, but I try not to say I think it's a silly question. Not today. There have been other times.
And sometimes the questions are not. There's different reasons why questions are asked. So that's the other thing I would say. Don't always try to anticipate what the judge is asking. Sometimes judges ask questions to hear themselves talk or something. Except for Judge Bass. Anybody have any questions of Mr. Levine?
Not good.
You put them right to sleep. Good job. No, this is a good argument. You guys did a nice job. Mr. Hoogland.
Yes.
Tell everybody about, and then you actually were the trial lawyer.
Yeah, if it pleases the court, folks, as you can see, I've been doing this for quite a bit longer than my opponent. I went to Stetson. I graduated in 1977. I've always been more of a country lawyer, I guess. My office is in Ridge Manor. I'm a sole practitioner. It doesn't mean I'm a fool, but I have a more varied practice. I've always been in court a lot. My initial background was a public defender. I did probably 50 to 75 trials as a public defender.
That's representing criminal people charged with crime.
Yeah,
right? That's a public defender.
the public defender is somebody that's appointed to represent indigent people in criminal cases. So I did a lot of that, perhaps 5 or 6 murder trials, 6 I believe. Then, as things happen, I kind of gravitated into civil work and still do a lot of both of those things, including the foreclosure cases. I have always done my own appellate work, so it's not like I'm saying it's the first time I've been in front of an appellate court, because I've always done it myself, so I have some experience. I'm not like a specialist, but like the gentleman over there. So that's kind of what my background is. I'm old enough to have 2 kids and 4 grandkids, so that's probably the most important part.
How long did it take you to tell us the difference between being the trial lawyer and an appellate lawyer?
The trial
Not
lawyer.
that I know the deal, man. I know. I get it, I think.
The trial lawyer probably plays more to emotions, although there's evidence that has to be introduced, and there's nuances. The presentation is important. Your client's there, how the client reacts, how the client interacts with the jury, the demeanor of the client, the demeanor of the witnesses. All of those things are integral to a jury's decision, and sometimes even to the decision of the judge, who should take things perhaps more neutrally, but judges in non-jury trials are still human. They're going to be affected by the emotions. So very much of what we do in a trial court depends on clients, how they play, how they look, how they act, how it's presented, because that will often mold or produce the outcome. When we're in an appellate context, which is what we here are today, the judges don't see our clients. They are much better at staying away from the emotion of the case. They're looking more at what was said. They assume that the judge that heard the case made the correct determination as far as credibility. So they pretty much don't get involved in saying who's right or who's wrong. This appellate court, no matter how much they may look at a case and say, I think it's fair or we think it's unfair, if there's evidence in the record to support the decision, either of a jury or judge, they can't change it even if they want to. So that's the change. So when
You're
we're
making
here,
Mr.
I
He's
apologize.
argument right there. I think you're making his argument right there.
That's why I
That's right. See what he just said? Yeah.
but it's a difference in focus and it's a difference in emphasis, the way that the case comes up in front of the appellate court.
So we don't weigh the evidence. We don't have any ability to say, well, we think this is a truthful witness or not. We just, what we get up here is just the record, the paper that's all been typed up by the court reporters. And so we're able to read what happened below, but we talk more about legal issues as opposed to do we believe this witness or that witness or what have you. Anybody have any questions for this counsel? Or of the court, or of the judges? We won't restrict it just to the students. I guess if any of the trial judges anybody had any questions. All right. Gentlemen, thank you for coming to Ocala today. We appreciate your participation in this process with the students in our early law day session.
Thank you very much.
Thank you, counsel. Well spoken today. All right.